And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
We have some absolute breaking news in the ongoing battle to end the NFA's stranglehold on suppressors. And honestly, this one is a roller coaster of legal contradictions. The Trump Department of Justice just pulled a stunning reversal, officially admitting in court that suppressors are, in fact, protected arms under the Second Amendment. But then, in a move that feels like a total betrayal, they turned around and argued that the government can still restrict them through the National Firearms Act anyway. You need to hit that subscribe button right now because we're breaking down what the Fifth Circuit Court of Appeals just ordered and exactly why this decision affects every single gun owner in America. Welcome back to Law Advisor. We are pushing hard for that 1,000 subscriber milestone, and your support by subscribing and sharing these videos is what allows us to keep digging into the dockets that the mainstream media completely ignores. Now, let's talk about this stunning reversal from the DOJ. The Trump administration's Department of Justice came into the Peterson case and did something that shocked the entire Second Amendment legal community. They officially conceded that suppressors are protected arms. This wasn't just a minor footnote. It was a direct admission that overturns decades of government policy. For years, the government's line was that suppressors were merely accessories or tools that didn't deserve any constitutional protection at all. But as of 2024, with over 8 million registered suppressors in civilian hands, that argument finally collapsed. The government finally admitted what we've all known for years. These are bearable arms, in common use for lawful purposes. And under the Bruen standard, that means they are presumptively protected by the Constitution. But here is where the betrayal happens. Even though the DOJ admitted suppressors are protected, they immediately argue that the NFA can still restrict them. Think about how absurd that position is for a second. It is like the government saying, yes, you have a fundamental right to free speech, but we can still make you pay a special tax, wait 6 months for a background check, and submit your fingerprints before you're allowed to say a word. The DOJ claimed that the NFA operates as a shall-issue permit scheme, and therefore it survives constitutional scrutiny. But the problem is that the NFA was never designed to be a permit system. It was designed back in 1934 to price average Americans out of ownership entirely. That $200 tax in 1934 is equivalent to about $4,000 today when you adjust for inflation. Congress explicitly said during the original debates that they wanted to make these items so expensive that regular people couldn't afford them. So how can something designed to prevent ownership suddenly be rebranded as a reasonable permit scheme? What's even more disturbing is how the Fifth Circuit responded to this contradiction. In a unanimous decision, all 3 judges on the panel agreed that even though suppressors are protected arms, the NFA doesn't violate the Second Amendment. This is the same Fifth Circuit that has issued some of the strongest pro-Second Amendment rulings in the country lately. But in this case, they completely twisted the Bruen standard to give the government a pass. They ruled that because the NFA eventually approves most applications, it functions like a concealed carry permit system. But Bruen was talking about simple background checks and minimal fees, not a scheme that costs hundreds of dollars, takes a year of waiting, and puts your name in a federal database like you're a criminal suspect. The only reason the NFA has a high approval rate is because the process is so burdensome that it weeds out everyone except the most dedicated and wealthy applicants. If this Fifth Circuit reasoning is allowed to stand, it doesn't just affect suppressors. It gives the government a blueprint to defend every single restriction under the National Firearms Act. We're talking about short-barreled rifles, short-barreled shotguns, and even the ban on new machine guns. If the government can argue that the NFA framework itself is constitutional as a shall-issue permit, then they can defend the 1986 Hughes Amendment by saying it's just an extension of that regulatory power. Anti-gun groups have already explicitly stated that they want to do to suppressors exactly what they did to machine guns, freeze the registry and drive the prices into the tens of thousands of dollars. Some states are even using this Fifth Circuit decision right now as justification to draft their own state-level NFA registries for items that aren't even federally regulated. The logic used here could be applied to virtually any gun or accessory. If the government can impose a tax and a year-long delay on a suppressor and call it a permit scheme, then what's stopping them from doing that to handguns or AR-15s? Several states have already tried to implement expensive permitting schemes for handgun purchases, and New York's pistol permit system can already take over a year. The Fifth Circuit just gave them the legal theory to expand these schemes to every common arm in existence. They could say, you can own an AR-15, but only if you pay $500 and submit to a home inspection first. This is a dangerous path that effectively makes gun ownership impossible for working-class Americans. But here's where the story gets urgent and personal. We need to talk about the human cost of this case. Mr. Peterson, The man at the center of this battle isn't just a legal theory. He's a real person who operated a home-based gun business in Louisiana and is now facing prison time for possessing a single unregistered suppressor that was found in his bedroom safe. After the Fifth Circuit upheld the NFA, Mr. Peterson's attorneys asked the court to pause his case while they take it to the Supreme Court. Even the Trump DOJ agreed that it was reasonable to let him stay out of prison while the High Court decides whether to hear the case. But the Fifth Circuit denied that request anyway. Right now, Mr. Peterson could be ordered to report to federal prison, even though he has an active petition before the United States Supreme Court challenging the very law he was convicted under. Think about that. The government admits the item he had is constitutionally protected, yet he could still go to prison while the highest court in the land considers whether his conviction is even legal. The Fifth Circuit's order denying his stay was just 2 sentences long, with absolutely zero explanation for why they refused such a reasonable, unopposed request. Mr. Peterson's legal team is now preparing an emergency application directly with the Supreme Court justices. These emergency applications go directly to Justice Alito, who oversees the Fifth Circuit. Justice Alito has been one of the most vocal defenders of the Second Amendment, and he has the power to grant a stay on his own. If the Supreme Court takes this case, it would be the first time since Bruen that they directly address whether the NFA's restrictions on any category of arms violate the Constitution. This case checks every box the Supreme Court looks for. It presents a clean factual record in a lower court that has badly misapplied the law, but we also have to look at the political dynamics at play here. The Trump administration's position reveals a troubling reality. Even though Trump has talked about supporting suppressor deregulation, his Department of Justice is in court right now defending the NFA. Why? Because the DOJ has institutional interests in preserving its regulatory power and defending past convictions. If the Supreme Court rules that NFA suppressor restrictions are unconstitutional, it could vacate thousands of convictions nationwide. That creates what the feds call chaos to our citizens, and they will fight to avoid it at all costs. The ATF also has a major financial stake here. NFA taxes bring in over $90 million in revenue a year. They aren't going to give up that revenue stream without a fight. This is why we can't always count on any administration to do the right thing without massive public pressure and clear Supreme Court mandates. The institutional incentives are all pointing toward defending the status quo, regardless of what the Constitution actually says. But the historical record is on our side. Under the Bruen test, the government must prove that modern regulations are consistent with our historical tradition. The NFA didn't exist until 1934, over 140 years after the Second Amendment was ratified. There were no suppressor regulations at the founding or during the Reconstruction era. In fact, for the first 30 years of their existence, Americans could buy suppressors through the mail with no paperwork and no taxes. They were even advertised in sporting goods catalogs as a courtesy to your neighbors. The government simply cannot point to any founding-era law that taxed or registered firearm accessories. Their entire defense rests on the Fifth Circuit's willingness to ignore history and redefine a tax scheme as a permit. This is exactly why we need Supreme Court intervention to restore our constitutional protections. This case will determine whether the Second Amendment actually protects your rights, or whether the government can simply tax and regulate them into oblivion. We are going to be tracking every single development as this case moves toward the Supreme Court. If you care about the future of your rights and want to stay informed, you need to subscribe to Law Advisor right now and hit that notification bell. We are on the road to 1,000 subscribers, and we want you to be a part of this community of informed, armed scholars. Drop a comment below and let me know, what do you think about the DOJ's double talk in this case? Do you think suppressors will finally be removed from the NFA? Let's get the discussion started. Thanks for watching, stay safe, and I'll see you in the next one.